Hello, everyone, and welcome to our third event of the day for the Border Immigration and Refugee Crises Day. I'm so excited to introduce Andrea Nunez. She is a Connecticut native at the University of Connecticut School of Law in Hartford, Connecticut. She obtained her undergraduate degree in global studies from Lesley University and a master's degree in refugee and forced migration studies from DePaul University. Andrea has been engaged in immigrant rights advocacy since youth and volunteering in a number of capacities for 10 years, over 10 years. Prior to starting law school, she worked as a paralegal at the Catholic Charities of Chicago, assisting immigrant survivors of domestic violence and sexual assault applying for U visa and VAWA relief. She speaks Spanish fluently and is conversational in Portuguese. And today she will be giving a Know Your Rights session, which will discuss ways to handle difficult situations surrounding immigration. And the purpose of this is to educate allies and give those at risk of deportation a way to know the rights that they are entitled to. So I will now hand it off to Andrea.
Thank you so much, Priya. So hi, everyone. I'm Andrea. So the beginning part of this presentation, I'm going to talk about some forms of immigration relief, and then later I'll talk about language when presented with ICE and how to protect yourself and know your rights in those situations. So I just wanted to note that I won't be doing Q&A just because I'm not an attorney and there's not an attorney doing this presentation with me. So, it would be harmful to people asking questions because there's, no attorney to confirm that my answers would be 100% correct. And it would also be harmful to me for the unlawful practice of law. But even if there was an attorney present, immigration is just so complex that it's oftentimes very difficult to properly answer someone's question without knowing an extremely detailed account of their immigration history. But I did want to note that this presentation has been thoroughly reviewed and edited by an attorney, attorney Valeria Gomez, who I thank a lot for all of her help. So yes, I'm going to begin now. So the first remedy I'm going to talk about is called the U visa, and it exists for people who have been victim to certain crimes here in the United States. There's about 30 qualifying crimes, which include domestic violence, sexual assault, and felonious assault, among others. So to qualify for the U visa, you have to have been the victim of one of these crimes, reported to the police and cooperate in the police investigation or prosecution if they ask you to, which in some instances includes, testifying in court if you're asked. But in some circumstances, if you have a minor child who is the victim of one of these crimes, you can also qualify for a U visa. And it doesn't matter if the child is a US citizen or a non-citizen. So to be able to apply for this visa, you do need law enforcement to sign a particular form where they describe how you are helpful, and an attorney or an accredited representative can help you with that process. The next relief I'll talk about is called, the acronym is VAWA, or the Violence Against Women Act. So VAWA is a legal remedy for people who are married to abusive US citizens or permanent residents, which are permanent resident, sometimes we know that as like green card holder. So the abuse can be physical, psychological, economic, and sexual. And to qualify, you do need to have lived with the abusive spouse at some point during the marriage. You need to have entered the marriage not only for an immigration benefit, and you have to show that you're a person of good moral character. To qualify for VAWA, you do not need a police report, and you can apply while you're still married or in a relationship with the abusive spouse. And if you have been divorced from the spouse, you have to apply for the relief within 2 years after the divorce. And then another way that a person may qualify for VAWA is if they're under 21 years old, they're not married, and they've been abused by their US citizen or permanent resident parent. And you may also file for yourself as a child after 21, but before age 25, if you can show that the abuse was the main reason for the delay in filing. There's another legal remedy for undocumented children who have been abandoned, neglected, or abused by one or both parents, which is generally known as Special Immigrant Juvenile Status, or SIJS. So this is typically a two-step process. The first being you have to go through a court process in the state where you're living. So, here in Connecticut, and then a local judge directs an investigation and afterward gives a guardian or parent custody over the child and rules in writing that the child was in fact abused, neglected, or abandoned by a parent, and that it's in their best interest to not return to their home country. Afterward, the child's representative sends that order along with an application for SIJS to immigration, where if they agree that the judge did what the judge was supposed to do and that the order wasn't solely granted for immigration purposes, SIJS is granted. And having SIJS means that eventually the child can apply for a green card. So a lot of times, unfortunately, people who have entered the US without permission or hidden, they find that their unauthorized entry makes it hard for them to apply for immigration remedies, even when they otherwise seem to qualify for a green card or other kind of relief. But the great thing about U visa, VAWA, and SIJS is that it may be possible to qualify for these forms of relief, even if you entered the US without a visa or without permission, although it may require filing additional paperwork or waivers to do so. Some people are eligible to obtain status through marriage to a permanent resident or a US citizen. Depending on how the person entered the country, though, the process may require that that person leave the country briefly, like if they entered the United States without inspection, or it may allow them to remain in the US during the process if they entered with inspection, even if their visa expired and they overstayed. But whether or not someone is eligible to get status through marriage is very case specific. And some people may have bars to re-entering the country if they try leaving, the US to finalize their green card process. So it's important with all of these remedies to really get quality legal services, but especially with marriage, it's just extremely important to consult with an expert before moving forward on your own. And then the final relief I'll talk about is called cancellation of removal, and that's a way of obtaining permanent residency or a green card for people who have been continuously present in the US for at least 10 years and who are in removal or deportation proceedings. There are various requirements for this remedy, including a showing that the person is of good moral character and a showing that the person's deportation would cause exceptional and extremely unusual hardship to a qualifying relative, which could include a green card holder or a US citizen spouse, child, or parent. So I do want to emphasize that the descriptions I've just given of these important immigration reliefs are for general information purposes. And I just really want to note that they have been greatly oversimplified. So there may be risks associated with filing for any of these, but if you think that any of what was just described might be a form of immigration relief that could be helpful for you, a friend, a family member, I really recommend doing a consultation with an immigration attorney or a person who's called a Department of Justice accredited representative, which is someone who's not a lawyer but works with a nonprofit organization, has gotten specifically trained or authorized to represent people with immigration proceedings and paperwork for a lower fee. So they will know the questions to ask to ensure that you qualify for one of the reliefs and to make sure that you're not disqualified for a crime or immigration related reason. And they also will be able to explain whether or not it'd be risky to file for an application, so that you are really empowered to make the decision that you feel is best for yourself. So yeah, I just really want to emphasize that. Now I'm going to just talk about so we might have heard recently in the news that there have been several bills or several laws called bills that have been proposed that would provide a pathway to green cards to people who currently are not eligible for green cards. So I just wanted to outline a few of these for you so that you could track them and know what they propose. But I just want to be clear that at least as of today, they're still being debated in Congress. They might be revised in negotiations between lawmakers, and they have not been fully passed into law. So there's no guarantee that these bills will ever become real laws. So I just want to recommend that people be extremely careful not to pay money to a representative or an attorney who claims that they can get you papers through these new laws. A reputable attorney will never take your money until a final law is passed. And then Deanna there should be posted. I'm not sure exactly where it is. I'm a little confused by the logistics of it, but I have sent over a list of nonprofits in Connecticut that are reputable, but that list is not exhaustive. There's also private attorneys and other nonprofit organizations in Connecticut that people can reach out to. So just a background, so the American Dream and Promise Act of 2021, or HR 6, would provide a path to a green card, and for those interested, also citizenship for certain undocumented immigrant youth, known as Dreamers, as well as individuals with temporary protected status. On March 18th, both the American Dream and Promise Act and the Farm Workforce Modernization Act passed in the U.S. House of Representatives with bipartisan support. And so now the Senate must act and bring these bills up for a vote. So Dreamers, individuals eligible for TPS or deferred enforced departure, are eligible for permanent residence, or would be eligible for permanent residence through this bill. And again, I know I've said this multiple times, but it's just really important to do a consultation with a trusted legal organization or attorney. I do want to note that notary publics are not attorneys in the United States. They oftentimes have no kind of formal legal education and do not pass a licensing test that allows them to legally be able to help someone with immigration paperwork. If someone who's a notary public is giving legal consultations or filing paperwork, they're probably breaking the law. But aside from that, there's just a lot of fraud in the US with notary publics trying to take advantage of the immigrant community, unfortunately. So I just really want to emphasize that people be careful with that. And again, the list that I have provided to Vienna, it's not exhaustive, but it does provide a number of nonprofits that do this type of work. And so if anything that I've said in the last 15 minutes sounds like something that you think would be you have a friend or a family member or yourself, you think that maybe this would be beneficial, I just really recommend, or if you think, oh no, I don't think that I'd qualify. Either way, I really just recommend doing a consultation because you might have done a consultation in the past and told that you didn't qualify, but a change in life circumstance or a change in the law may make it that you're now eligible. So I just really encourage consultations. So now I'm just going to talk about vocabulary in exercising rights when confronted with ICE. So language like I wish to remain silent, I wish to make a phone call, I wish to speak with a lawyer, I do not consent to your entry or search, I will not sign any document I do not understand, am I under arrest, am I free to leave? These are all examples of language to use if confronted with immigration officers. And so immigration officials or ICE, if they come to you at home, you do not do not open the door. And if there's children in the household that you live with, it's important to teach the children, your kids or younger siblings, whomever, just to not open the door. And you're not required to open the door unless ICE has a warrant that's signed by a judge. So you can ask ICE to show you the warrant by sliding it under the door or holding it up to the window. If they try to force the door open, make sure to write down the agent's badge number and vehicle license plate number. And it's important to know that if you let an ICE agent into your house or if they force themselves in, they're allowed to arrest anyone who is there without papers, not necessarily just the people that they said they were, there to arrest. And just a note, a real warrant will say something, will say U.S. District Court for blank at the top. So if that's not there, there's no requirement to answer the door. So I'm just going to now talk a little bit about the difference between police and immigration and the different proceedings. So with police, to the court, if you have court or probation and you do not go, the judge issues a warrant for your arrest and you must pay 10% of the bond to be released. With immigration, if you have court and you do not go, the judge will issue an order of removal. And that means that the judge made a legal decision, even if you were not present, that you should be deported. And you can only reverse this if there's truly exceptional reasons for why you were unable to make it, but reversals unfortunately are very rare. And then with bond for immigration, you must pay 100% of the bond to be released. And the person who pays the bond must be a US citizen or green card holder. So just a number of common events that may lead to detention or deportation, driving under the influence, other arrests, filing immigration applications when not eligible, and having a prior deportation order. So it's really important for folks to have action and safety plans. Unfortunately, certain people are obviously targeted when driving. So like to check taillights and make sure that they're operational because, a person can get pulled over for that. And then unfortunately, it can just lead to many negative consequences, including for immigration purposes. And then keep your passport and identity information and proof of physical presence in the US and financial information like in a safe location, and have an emergency contact who knows like where all of that information is stored. And then, in that same safe location, if you have children or if you're like the primary caretaker of children, keep information, on the kids, so their name, date of birth, place of birth, their birth certificates, and then any health conditions or allergies or medications pertaining to the child, and then provide your child's school or kids that you might take care of with the emergency contact name and phone number, and provide an authorization for the emergency contact to pick your child up. So that, I think I just reached 20 minutes, right? So that concludes this general overview of different immigration benefits that people might qualify for, as well as language to use if confronted with ICE. Again, it's all been a very general overview. So I just really want to encourage people that if they're unsure or they think they might, qualify for something, to really make a consultation with a trustworthy attorney or with a nonprofit that might have DOJ accredited reps. And yeah, so that concludes my presentation. Priya, thank you so much. And I hope everyone has a great day.
Thank you, Andrea, for being here, and I'm confident that your presentation provided some really helpful tips and resources to those who may need it. And as Andrea mentioned, I just want to let everybody know that we will attach some resources on the Human Rights Symposium webpage. And yeah, thank you again, Andrea.